Getting ready for our last panel of the day. It is an exciting one. So I'm going to turn over to Bob Barnes of the Washington Post to talk about Bruen and Dobbs.
Hello, everyone. I've learned a lot today. I hope you have too. We're doing guns and abortion. Blah, blah, blah. If you don't already know I'm not going to introduce the panel because if you don't already know them by now, you haven't been paying attention. And it's too late to cram for the quiz now. We're going to talk about two big cases from the term, and not just we will talk about what those cases said, but we'll also talk about what comes next after them, because despite what the court said, I don't think that they have completely rid themselves of these two issues yet. And so first off, my friend and colleague, Adam Liptak, will be telling you what happened in these two big cases of the term and what didn't happen in them.
So just to review the bidding before we get to the interesting part, the court said abortion is not a real right, and therefore states can do whatever they want in the realm of abortion. Keeping and bearing arms is a really important right, and therefore states can do very little to regulate in the area. More specifically, Justice Alito said that rational basis review applies to abortion laws. Helpfully, he goes on to say that not only can states regulate abortion for legitimate reasons, he lists every legitimate reason he could think of, including respect for and preservation of prenatal life at all stages of development, the protection of maternal health and safety, the elimination of particularly gruesome or barbaric medical procedures, the preservation of the integrity of the medical profession, the mitigation of fetal pain, and the prevention of discrimination on the basis of race, sex, or disability. He says nothing about whether, even so under rational basis review, whether the Constitution might require exceptions for the life and health of the mother, for pregnancies that are the result of rape or incest, or the treatment of fetal abnormalities. Then there's a characteristic and cryptic and seemingly dashed off Kavanaugh concurrence, where he muses about the right to travel. And he says, in my view, you can't bar pregnant people from going to other states based on the constitutional right to interstate travel. That is to say that there is no right to abortion in the Constitution, but don't worry, your right to travel, also not in the Constitution, is protected by the Constitution. Now, the Thomas opinion in Bruen takes an entirely different approach. It says that where the Second Amendment's plain text covers the right to bear arms, the government has to justify regulations based on the nation's historical tradition of firearms regulation. And then it gets quite complicated because so much of what gun regulation there was in history is unlike gun regulation currently, that you have to reason by analogy, and when the analogy fits or not entirely clear. But he says that analogical reasoning under the Second Amendment is neither a regulatory straitjacket nor a regulatory blank check. And then here we go again, Kavanaugh concurs, and he seems to accept, but writing only for himself, a great deal of regulation. So-called shall issue objective licensing schemes in 43 states, he says are acceptable, including fingerprinting, background checks, mental health records, and training. And he also reprises the big caveat that was the price of Kennedy's vote in Heller, where the Heller court said that all kinds of gun regulations are presumptively valid. But that's Kavanaugh speaking for himself. So that's the overview of what happened.
Okay. these cases are different, similar in some ways. You're going to tell us what we know about how the court sees these constitutional issues because of what they said in these two cases, right?
Yeah, well, I'll try anyway. So I want to start by imagining the following is the opening paragraph of the Bruen decision. So as a sort of thought experiment, imagine that Justice Thomas had written the following: firearms possession presents an issue on which Americans hold sharply conflicting views. Some believe fervently that firearms pose serious threats to public safety and impose significant social costs. Others feel just as strongly that any regulation of firearms invades a person's right to self-defense. Still others in a third group think that firearms possession should be allowed under some but not all circumstances, and those within this group hold a variety of views about the particular restrictions that should be imposed. And assume further, the court went on to say we must be scrupulously neutral with regard to the issue of firearms, and therefore rational basis applies to any future firearms regulations. Of course, that's not what Justice Thomas wrote. That's what Justice Alito wrote about abortion in the opening paragraph of the Dobbs decision. So the decisions have a lot in common, right? Among those things, they of course address divisive issues. Americans disagree about how these rights should be, whether they should be recognized and how they should apply. They both rights address matters of life and death. I think it's fair to say, Justice Alito in Dobbs pointed out for 185 years prior to Roe versus Wade, states had the authority to decide, or their citizens at least, through their representatives, how the abortion right should be enforced. One could also say the same thing, I suppose, for a longer period of time about Second Amendment rights between the period of the ratification and Heller in 2008 and McDonald in 2010. In terms of methodology, both decisions apply what you might call history and tradition or originalism by another name. So there's a lot in common between these two decisions, but I think that's where the principal similarities end. As Adam points out, Dobbs de-recognized an abortion right that had been recognized for half a century, finding no historical support for it, while Bruen likely strengthens the Second Amendment right that Heller and McDonald found significant historical support for. Dobbs, as Adam pointed out, adopts a rational basis standard going forward for abortion regulations. And in Bruen, the court adopts a, I think, rather rigorous history and tradition test for future gun regulations. Dobbs purports to send the matter of abortion back to the states. I've read that a number of times in different accounts, but what it actually says is to the people's representatives and legislative bodies, which may implicate Congress in future abortion regulation. While Bruen, of course, will make it, I think, much more difficult for states and localities and the federal government to regulate public carry, high-capacity magazines, semi-automatic weapons, and the like. So what accounts for the differences in the treatment of these two rights? Well, maybe it's the text. The court says, in the Dobbs opinion, abortion is not explicitly recognized in the text, nor is it implicitly supported by any provision in the constitutional text. By contrast, in both Heller and in McDonald and now in Bruen, the court says there is significant historical support for an individual right to keep and bear arms. If it's all text, and I'm sure we'll get into this issue in just a couple of minutes, what then of rights to same-sex marriage, contraception, parental rights, none of which are explicitly recognized in the text of the Constitution? Is the distinction a matter of history and tradition? Does the court in fact have it right? The abortion right is simply not recognizable because it is not deeply rooted in history and tradition, nor is it implicit in the concept of ordered liberty, whereas the Second Amendment individual right to keep and bear arms is. As everyone on this panel and all of you I'm sure know, the answer to the question why the divergent treatment is far more complex than either of those two things. I think the answer lies in decades of political activism at the local, state, and federal level, litigation, public debate, academic work, and of course, judicial appointments. all of which culminated in what's essentially the eradication of the abortion right, and in my view, at least, the elevation of the Second Amendment right. So I think that covers where we are, and I think now we want to talk about where we're going.
Well, we got one more thing we want to talk about because, it wasn't enough just to decide abortion and guns. Justice Thomas thought maybe he'd throw in a few more things in his concurrence about what he sees the future to be. Willy, tell us why he did that.
So let's go over all of the things he said in the concurrence, because little known fact, right? This concurrence suggests Justice Thomas's willingness to recognize all manner of unenumerated rights. He just thinks it should be done under the heading of the 14th Amendment Privileges and Immunities Clause, a provision that nobody gives any effect to and hasn't since the slaughterhouse cases. But he says that the way in which the court has been doing unenumerated rights for the last, 50, 60, 70 years is wrong, and that the court should repudiate it, not just in this one case, but repudiate it root and branch, which means as to legal reasoning, overruling 3 cases, right? He lists Obergefell, he lists Griswold, and what's the other one that I'm forgetting? Lawrence, thank you, but not Loving, which we can come back to, right? But I think remember that in Lawrence, Justice Thomas had written a concurrence saying that this, as in Griswold, was an uncommonly silly law. So I think that the answer to your question, Bob, why did he write this, is that this is a doctrinal attack on substantive due process specifically, not a concurrence saying these are not even saying these are not protected by the Constitution, and certainly not saying I look forward to a day when contraception is illegal.
Do no other justices agree with them? Do you guys think, is that why there was no one else on this concurrence?
I'm not sure that why.
Yeah, I'm not sure that's true. I mean, I'm just not sure, and nobody else has staked out that position yet. But I think it's more likely some of them just didn't feel the need to say it.
Well, but remember in McDonald, the court invited you guys in essentially to argue for the incorporation of the Second Amendment because they didn't want the privileges and immunities.
That court, we
there.
know none of them except for Thomas thought it. We do have some new members.
Yeah, that's true.
I don't know for sure what the new members think, but I mean, I think what you said is absolutely correct, that the oft ignored part of the Thomas concurrence is the very next sentence that says, these may all be rights that could be recognized under different theories, just not this one.
It's hard to see how engaging in consensual private sex is part of the privileges or immunities of citizenship, as opposed to something that would be true either for all people living in the United States or none. And I mean, that's the thing about the privileges and immunities clauses. It's the privileges and immunities of citizenship, which means if that's what protects the right, then all of the people in the United States, whether here lawfully or not, who are not citizens, have no right to do whatever it is.
I'm quite confident all of this will be litigated in contexts where people actually pull out these arguments. I do think the important thing to recognize, as you said, is that he didn't write an opinion saying, I look forward to getting rid of all of these rights. I look forward to getting rid of substantive due process, which nobody else even seems on board for.
Right. Well, and recall that the majority opinion says, for stare decisis purposes, abortion is different. And he said in his concurrence that he joins that discussion because he does see it as different. It may well be that the others would stop right there and say, for stare decisis purposes, abortion is different, and therefore we would go no further. I'm certain that that is true of at least some of them.
Yeah, let's talk about that. In that, for what was it, 10 years, the court refused to take up a gun case that would sort of further explain what the Second Amendment right protected and provided for. Took one case that was mooted out, and so it didn't get to a decision in that. So it was a long time coming, it felt like. Abortion, I think all of us here, maybe for over the last 2 years when we would talk about it, couldn't quite imagine Roe being overturned. We thought there would be some middle ground, or we thought that there would be some compromise, or that the Chief Justice would be successful in his incremental approach to looking at this issue. So how surprised were you guys with the outcome and overturning Roe? Adam, I know you already had 3 leads written, or 4.
Going into the argument, I thought there would be what turned out to be the chief's view only would be the dominant view. And I don't think that was unusual. And in fact, the abortion rights side was very much telling the press, don't characterize that as a win for us. That's a terrible loss. That does away with viability. That does away with the essence of Roe. And I went into the argument thinking that was the likely outcome. And I came out of the argument thinking, oh my God, they're going to overrule Roe.
Yeah, I mean, but once you saw what happened in the Texas SB 8 case, I didn't see how they were not going to overturn Roe. I mean, the refusal to stay that case, which was a case where, you know, they were infringing on the right as announced in Roe undeniably. And I understand the complications of the 1983 ex parte Young business, but you would have thought the Supreme Court would have at least wanted to keep the status quo in place if it thought it was going to keep some version of the status quo in place. But what then became clear between that and some of the legislation in other places is the Supreme Court either had to get rid of Roe or it was going to have 15 abortion cases on its docket in the next term and a half. And that's really not something they want. I mean, that is not a good look for them.
What about either of you? I mean, did you think?
I was at a rival conference a year ago and predicted the outcome, but
You did?
I thought that I was 100% clear from Justice Kavanaugh's line of questioning at the argument.
Yeah, I mean, you know, like, I think a year and a half ago or 2 years, I'm pretty sure I confidently said like, no, that's not gonna happen. But then like once I think as you guys said, a lot changed in a very, very short period of time. And between kind of the way the case was briefed, the Texas stuff, the reality that the court was not going to get out of all of this, like I very much, you know, came out of kind of even before the argument, partly just from my own experience, kind of learning more about the case once I sat down and read briefs and actually moved people to talk about it. But, you know, it was not surprising at the outcome at that point. But I do think it shows how much change in a very short period of time, because I think even a couple of years ago.
I assume you mean before the draft opinion leaked.
Yeah.
Yes.
We all do. But I mean, I told my constitutional law students last spring that what I was teaching them was probably good until June, which probably got us under the wire in the exam, and sure enough it did. But after that, notwithstanding this, that we hadn't asked for it, it struck me that that's where we were headed. And part of the reason I thought so is that you've always had this precedent sitting after the Glucksberg case, which involved physician-assisted suicide. And the methodology there is to find the right at the narrowest possible, and then ask whether it is deeply rooted in history and tradition. And I thought once you got 5 or 6 justices who followed that methodology, then the argument that, well, abortion is different plus that probably led you right where we are.
Does anyone think if the abortion rights side had accepted this sort of compromise position or had argued for it, and Adam's right, they strenuously, in talking to reporters and we saw it to the court, rejected that idea? Do you think that that would have made a difference?
Sorry,
If the abortion rights,
abortion rights side or the,
yes.
Are you suggesting like that the council should have been Neville Chamberlain going up there and saying, well, we got these for our time? I mean, once you say 15 weeks, it's like, I'll see your 15 weeks and I'll lower that 3 weeks. And then, oh yeah, well, how about 6 weeks? And then what about conception? I mean, I just don't see how accepting that compromise wouldn't just mean, you know, you're going to see another case coming down the pike with you can't negotiate against yourself. And so there isn't a compromise out there that's stable if you've got what you have, which is a number of states that want to ban abortion either altogether or in any case other than rape and incest or, saving the life of the woman. Once you've got that as the political goal of one side, I don't see what the compromise is that you can say to the Supreme Court, well, we'll accept this compromise and you promise us that this is going to be stable. I mean, how do they give you any promise that it's going to be stable?
Mechanically, it also wasn't possible given Roe, right? Because every lower court had to strike down every one of these laws. And it's not as if you could just then leave some lower court compromise intermediate position in place without a non-petitioner cert.
Can you tell us what comes next or what you see? And does the court next act on abortion in some sort of shadow docket emergency, do you think? Or will there be a sort of more thought out strategy?
So I think there are a couple of different things that can be coming down the pike. One set of things will involve the constitutionality potentially of various state laws or applications of state law. So for example, if you get an aggressive district attorney in a state that bans abortion altogether, who tries to apply the law in some extraterritorial way to aid or, so people in California advertise, come to California to get an abortion. Is it aiding and abetting in violation of state law if you intentionally direct your message into a state that's made abortion illegal? I think, I find it hard to believe that Justice Kavanaugh can actually think that there's a right to travel out of state to have an abortion once a state is entitled to define the fetus as a person. Because if you take your 2-year-old out of the state and kill your 2-year-old in another state, I have no doubt there's a famous double jeopardy case, Heath against Alabama, that the Supreme Court decided, that said both states can try you for murder. So yeah, the woman has a right to travel out of state. What she doesn't have a right to do is take the fetus with her for the purposes of killing it. So, you may see some cases like that. I think it'll take a long time for that case to get to the Supreme Court because it'll be a state court prosecution. You can't get an injunction against a state court prosecution. That's the Younger doctrine. So it'll take a while to work its way up. I don't think you're going to see a case like that in the short run. I think you may see some cases on the emergency docket if the administration does various things using administrative law to deal with preemption or the like.
Hospital regulation.
Yeah, you might see an EMTALA case get up there very quickly. You might see a case involving if there's federal preemption of state laws with regard to mifepristone or something like that. You might see that case get up there relatively quickly. So I do think there are some cases that might get there quickly. I think the kind of long-term, if you've got a case where a woman has an abortion and either she or the doctor is prosecuted for it and she now wants to argue that it was necessary to save the life of the mother, does the state have a compelling interest in choosing the life of the fetus over the life of the woman? That's a little bit of a tough issue. And this is an area where I think, if I could just say one other thing, that's interesting to me about the court's claim that abortion is different. Where I see abortion as arguably being different than contraception or is not on the nature of the liberty interest so much as on the nature of the state's countervailing interest in regulating. That is, consensual sex between two adults doesn't cause harm to a third party. Abortion does, and the state has an interest in protecting that third party, which is the fetus or the like. And what's interesting to me is the court didn't go in that direction, saying, yeah, of course there's a liberty interest in deciding how your body should operate, but it's outweighed. That seems to me a more candid way of saying what the court is really doing here than saying there's no liberty interest at all. And it's worth just remembering, that's a textual argument. That the 14th Amendment protects liberty is not a non-textual argument. I mean, liberty is in the Constitution. And I commend to all of you reading Peggy Davis's book on this, which was written in the 1980s, about what liberty meant to the framers of the 14th Amendment. And part of what it meant was the right of women to control their bodies, because that's what slavery meant. Women didn't have the right to do. Slave women were forced breeders. And there's lots of discussion of this in the history leading up to the 14th Amendment. And so there are arguments from history and tradition here on both sides. And so the real argument in favor of abortion regulation is, yeah, the woman has a liberty interest here, but it's outweighed by something else. It's not that she has no liberty interest. And so that was, for me, quite distressing that the court tries to suggest this isn't about a liberty interest at all.
What else do others think about what would come next?
I mean, I actually agree that I think that sort of the federal stuff is the most likely to get there, because as much as there's a lot of noise and like, yeah, there's some legislatures that put some stuff out there, I think it's less likely that you're actually going to have a state pass some of the types of laws that people are putting out there as hypothetical things. I think for the most part, the kind of the community that successfully pushed Dobbs like understands successfully how to push cases and not. And I don't think that, you know, people think that those are the cases and the laws that make sense to push. So I think it's more likely that in the short term, I mean, I hadn't thought about the sort of off the rails prosecutor kind of forcing issues, which makes some sense, but it seems more likely to me that you confront all of this in the context of you know, preemption in some of those issues, which all creates some fascinating dynamics. I mean, you know, for those of you who missed the business cases breakout earlier, like this is why you should all go and pay lots of attention to the pork producers case and the extraterritoriality doctrine. But you know, but there are some other doctrines and some strange bedfellows now in terms of doctrines that people, you know, didn't care a heck of a lot about a couple of years ago that they may feel very strongly in both directions about now because of their implications for both state and federal power to regulate abortion.
Overturn Wyeth, you know, the strange bedfellows coalition there too.
The free speech issue Pam alluded to, I think is maybe a big one. Aiding and abetting or advertising, it of course raises free speech issues. And I'll just put one piece of model legislation on the table that South Carolina at least has considered passing, and I wouldn't be surprised to see it enacted into law. It would criminalize, quote, knowingly or intentionally hosting or maintaining an internet website, providing access to an internet website, or providing an internet service purposely directed to a pregnant woman who's a resident of this state that provides information on how to obtain an illegal abortion, knowing that the information will be used or is reasonably likely to be used for an illegal abortion. It's going to spread to the internet as well, the effort to regulate information flow about abortion services. And I think the First Amendment case law here is unclear enough that I'm at this point not certain how those laws will play out. There are cases sort of running in two different directions involving one, abortion services, a case called Bigelow that struck down a Virginia law that prohibited New York advertisers from advertising abortion services in Virginia. And then there's a case called Edge Broadcasting, which involved advertising for gambling. The court upheld the regulation. So at this point, it's not clear how those will resolve.
Sounds like a dormant commerce clause fact pattern to me.
Yes.
Adam, you wrote about a story about, and you mentioned earlier, the right to travel. Justice Kavanaugh says, don't worry about it.
Yeah, so I'm with Pam. It's not hard to imagine situations in which it would happen. The Bigelow case had language in it saying that one state can't prohibit another state from doing things that are lawful in that state. The lineup in Bigelow was precisely the same as the lineup in Roe itself, 7-2 with White and Rehnquist in dissent, and Roe didn't fare very well, so I'm not sure whether Bigelow will be.
I mean, it seems to me it's quite, a whole lot depends on whether you're saying people who live in this state can't direct people how to, in this state, get an illegal abortion versus if you're talking about like someone in New York on the internet advertising for perfectly legal abortions in New York that somebody in Virginia can read. Like, I mean, that's it.
Right, I would hope the answer to that is
I would,
that that's protected.
I mean, I would like to think that, you know, that's.
Okay, so we agree. The other thing I could imagine, just to build on the hypothetical of the road prosecutor, I could certainly imagine states getting frustrated by not being able to stop their residents from getting abortions by instituting an SB 8 style law, which avoids, you know, some of these problems because it would just, you know, chill people.
For the longest time, one argument about Roe was that states were passing these extreme restrictions on abortion or bans because they knew that they wouldn't go into effect. There's no price to pay for the legislator who votes, who sponsors it or pays for it because it's not going to happen. And that would change if Roe was overturned. But it doesn't seem to me that the reaction by the states have fit that pattern at all. The states that you thought wanted to ban abortion have moved in that direction quite quickly. So was the sort of popular view of that wrong, regardless of what public opinion polls seem to say about the people thinking abortion should be available? Is it just not enough of a voting issue? And, you know, I guess to counter that, we do have some evidence that perhaps some of the congressional elections are going in a different direction because of this. And we have the Kansas vote. You know, I know the court doesn't do politics, but it seems like there's a lot of politics from this decision. Does anyone have thoughts about that?
I mean, yeah, for sure. You know, for many years, there were probably more single issue voters who were anti-abortion than single issue voters who were pro-abortion, and that made a difference in it made a difference in elections. Not clear that now that's true, whether in the short term or in the long term. So, you know, in that sense, you know, there are probably people for whom abortion now becomes a voting issue for whom it was not previously a voting issue. And I think at least so far that group tends to be breaking towards the pro-choice rather than the anti-abortion side.
I mean, this may tie into some of the election panels we've had today, where I would think that even in some of the states which are poised to or have enacted very dramatic abortion restrictions, that's not where the median voter is. But because of gerrymandering and other factors, you get unrepresentative legislation.
Doesn't it depend a little about if you're asking about the median voter in a locality versus nationwide?
No, I meant in the locality.
I mean, this is the different, this goes to whether, you know, if you have very gerrymandered districts so that they're safe one-party districts and the primary electorate is to the right even of the median electorate in that district, you may end up with a legislature that's prepared to pass a law that would never be passed if it were on the ballot as an initiative, right? I mean, I think, you know, there are a number of states in both directions, obviously, where the median voter in the state is not in the same position as the median voter in the state, the median representative in the state legislature.
Following up a little on Pam's point about single issue voters, it's not clear what in this environment a single issue pro-life voter is to do. Do you vote against someone who sponsored a 15-week bill because that's that's insufficiently rigorous, or do you decide that that's, you know, the best you can get in, you know, Michigan or wherever? I think the electoral complexities are now greater, I think, on the pro-life side, whereas I think the other side will be, it's easier to be a single issue voter. You're against any new legislation.
Okay, let's turn to guns. And Erin, I don't know how she would know, but she might know what the next kind of gun case would be for the court. Take a stab at it.
Or a shot.
So there's some cases that are kind of already out there and kicking around. There were a few issues that the court, the Supreme Court had petitions that it sent back down for reconsideration after Bruen came down. And those predominantly involve questions about kind of what types of arms are covered. So we had 2 magazine capacity cases. I think there's an assault weapons case that came down. So there's been a lot of litigation all along about that question of how you decide what restrictions the state can impose. How you figure out kind of what arms are the arms that cannot be banned, and most of these laws deal with flat out bans. So it really is a question that turns kind of on that. Are they? I mean, I think under the way the court now, so most of those laws in the lower courts before Bruen, the way that most most courts rejected challenges to high capacity magazines or so-called assault weapons or whatever it may be was by saying, we'll assume at least that these are constitutionally protected, but we're going to apply like the 2-step rationale the courts were applying to say these bans still pass intermediate scrutiny because they further legitimate state interests. Bruen threw out that test and said, no, you have to look to as a historical matter. You kind of apply a historical tradition test to decide whether laws are permissible. So essentially all of the case law that has held these types of bans on types of arms or magazines is, with the exception of like one court's cases, it's all out the window, and the courts really have to think about this from a totally new perspective. Those cases have gone back down, and by and large, the courts of appeals are sending them back down even to the district court, which means there'll be some time before they find their way back up to the Supreme Court.
Can I ask a quick question? So how does the historical analysis work in a case like that? High capacity magazines, unknown at the founding. What's the analogy? How do you do the work?
Yeah, so I mean, the court has made clear that the test that it's using to analyze whether an arm is protected is whether it is in common use for lawful purposes. And the court made very clear in Bruen that it applies that test by asking about common use today. So it views the historical test as is something in common use by the people, but you apply the historical test, not, frozen in time, such that you ask whether something was historically commonly used in 1810. You take the historical standard and apply it today. The reason all these courts had assumed without deciding that all these things are protected is because there's just like no question that that things like magazines with a capacity of more than 10 rounds or rifles with the type of features that are designated assault weapons, they make up like well over half of what exists in those in the marketplaces for magazines and rifles in the country, because they're not illegal in most of the states, and the people actually, where they're not illegal, really like them. So, if you take Bruen seriously, I actually think these cases are pretty easy at this point. Like, these are in common use. No one's really ever been able to dispute that they're in common use. So whatever else you can do, you can't just prohibit people from having them. So I mean, that's to me, the way you should be thinking about the test in these cases. I'll say I'd be pleasantly surprised if all the lower courts agreed with us that was the easy way to do it, just having 10 years of history litigating Second Amendment cases. But so that's a huge, I think that's sort of one of the biggest issues that's out there. The other one that is now, it's going to take a little longer, but is very much teed up is like the direct Bruen follow-on of, what Bruen actually held is that there's a right to carry a handgun outside the home for self-defense. But we never argued that that means you can carry it everywhere, and the court didn't hold that you can carry it everywhere. And they said, as a historical matter, there's a sensitive places doctrine that allows restrictions in sensitive places. The court offered, some thoughts about what is and isn't a sensitive place, but didn't purport to resolve for all time the question of sensitive places. And what we've seen in the wake of Bruen is states, a couple of states, New York itself immediately passing laws that designate, large portions of the cities and metropolitan areas to be sensitive places. So I think that litigation may even be what gets there sort of faster, especially if it looks like a real circumvention effort to essentially say, great, you can carry in all the non-sensitive places, and we've now defined 95% of, New York City that this case was about to be a sensitive place.
And is New York the only state that has acted in that way? Because they're the only one that's actually had their.
Yes, I meant to make sure I actually knew the answer to this question before today, but California has been working on this. I don't recall if they actually they have various legislation that didn't get passed, and I actually forget the final analysis of what got passed, but they are, kind of not far behind in their plan being to have a broad definition of sensitive places, or so it seems.
So those are what and where cases. What about who cases? In other words, like,
Age limits.
things like that. So
18-year-olds, nonviolent felons.
I think those have been, for a long time, the three major categories of who questions are the age limit, the nonviolent felons, and then can you have sort of your mental health issues in your youth follow you for the rest of your life, such that you're precluded from carrying a firearm because, you had a mental health issue when you were 16. And those issues have actually, and that particular issue, the mental health one, has actually did a little better than some other issues in the lower courts, even in a pre-Bruen era. But I think those are sort of the three major categories of who questions. And frankly, the age one is interesting because I think that's the easiest question in the world if you're taking seriously a historical test. I mean, it was required under the first act of Congress in this area that if you were 16, you had to possess a firearm. So sort of the idea that 21, which wasn't even the age back then, is the constitutional age doesn't make kind of any historical sense. But I'm not sure the court's going to be super anxious to take that issue up quickly.
Courts of Appeals also had cases after Heller about misdemeanants who are not specifically mentioned in Heller. And since those were all upheld under intermediate scrutiny, or means end scrutiny of some kind. So those might at least.
Yeah, but the more you're doing the who issues, I think you get into more of the reasoning by analogy that I was talking about earlier, because one of the big critiques people have always had of Heller was that the court just sort of said felon possession restrictions are permissible, even though it's a little hard to kind of trace them back. But so I think those cases will present a lot of opportunity to really explore how you do the reasoning by analogy in contexts where you don't have directly on point circumstances or
One of Justice Barrett's big opinions as a circuit judge was a dissent on the nonviolent felons. So things look pretty good for Clement Murphy altogether at the Supreme Court. I would say, does anyone have a dissenting view on that on the panel?
That it looks good for them. If they were selling stock, I might buy it. Go tell Karlan that. But the slipperiness of the look at the past to decide half of the analogy and then look to the present to decide the other half it's a little hard to figure out where that comes from as a matter of constitutional law, as opposed to a test that seems jury rigged to get to the outcomes that this court wants to get to. Because if you think about the tradition, traditionally there was no one in the country who had access to arms that allowed them to slaughter dozens or hundreds of their compatriots very quickly. And so I could see a version that said, a version of history says you have the right to a gun for self-defense. It's really hard to see how a lot of these guns are guns that involve self-defense at all. They involve something quite different. There also obviously was a back and forth about the history of what kinds of regulations were allowed at the time of the framing or in 1868 when the 14th Amendment was enacted or the like. And that tradition has gone out the window because instead the levels of generality have been moved up and down. I think, you and Paul have done a brilliant job of persuading the court of a test that reaches a particular result. It's very hard for me to see that test being applied to any other area of constitutional law. Because if it were, if that test, I mean, this goes back, Tim, to what you're doing, if you applied a test like that to abortion, a higher percentage of Americans today have had abortions than own large capacity magazines. So if we were saying, well, we take the idea of control over your body in 1868, and then we ask, how is that control over people's body being instantiated today? It's like a third of American women are going to have an abortion by the time they're 50. So maybe that should be treated as a liberty, but there's no way the Supreme Court does that here, but they do that with guns by saying, look at, you know, people's practice today, and that will inform how we think about the value that we started with from the time of the 14th Amendment or the time of the framing.
Despite your poker face, Erin, I think you disagree.
Yeah, it is how you go to history. I mean, like the difference, I mean, first, it's actually not true that, I mean, like magazines firearms capable of firing more than 10 rounds have been around for literally centuries, since before the country even existed. Like all sorts of rifles were made popular in the mid 1850s that fired, you know, could fire 17 rounds in under like 15 seconds and were easy to reload. So this, and the more relevant way to think about it is, once something was available, was it restricted? And if you think about abortion through that lens, like, yes, that was the whole history that I didn't even take the dissent to disagree with the majority in Dobbs about that. Yes, historically, abortion was actually generally prohibited. Conversely,
yeah, abortion after quickening was traditionally prohibited. Abortion before quickening was not traditionally prohibited.
sure.
And it was engaged in by large parts of the population.
Debate to be had about like quickening and where you want to draw the line. But historically, I mean, I think methodologically, I think the way you think about it is, when the opportunity, you know, when something was sort of available, how do you react to it? And for you know, if you're talking about some sort of arm or some characteristic of a firearm that's been available to the people forever, and it's not until like 1990 that a couple states start saying, maybe we don't think people should have this anymore. That's what I think the court is thinking about when it's talking about looking at, you know, history by analogy. It's not sort of just like, oh, we'll just take a snapshot of what's going on today. Some of it, you know, is in terms of, yeah, we understand that there's certain things that nobody had an opportunity to think about until certain points in our history, but it is relevant how people reacted once the opportunity to think about them came around. And I think that the history of abortion and guns are different in that respect.
Does the concept of forced self-defense do a lot of work here? I mean, I would think whether it's an ancient or musket that you could quickly reload, or an AR, I mean, it just a common sense matter. It's easier to be sympathetic to giving someone the right to defend themselves to the extent necessary, without giving them the right to slaughter schoolhouses full of little children.
Sure, but who decides what is to the extent necessary? Is that really the government's decision to decide? I think
That's right,
I think you need this much self-defense or more. I mean, that's the whole, you know. Some would say the whole point of the Second Amendment is the last people we want deciding is the government, how much we get to defend ourselves.
As you can see, my job is easy, but now it's your turn. And I'm starting over here because I was sitting over here and the moderator never turned. All right, so if you're good? Okay.
Yeah, if the Congress does, if the US Congress does pass a law basically codifying Roe v. Wade and instituting abortion rights nationwide, would that itself be challenged as unconstitutional? And if so, do you think such a challenge would be effective?
So it depends on how the law is drafted, right? And you could see a law that would be drafted, you know, using a bunch of Commerce Clause hooks that says essentially, you know, that preempts state regulation of the business of engaging in abortion. And under current Commerce Clause doctrine, I think that law would be upheld in the same way that the FACE Act was repeatedly upheld as an exercise of the Commerce Clause. Now, the agenda of at least, I think, part of the pro-life movement is to get fetal personhood recognized. Now, if you had a constitutional recognition of fetal personhood, then it's harder to justify a federal law or even a state law that treats fetuses differently than everyone else with regard to whether the state has an obligation to protect them, right? So if the state has a homicide law and says, I mean, it would violate the Constitution for a state to say, it's homicide if you kill somebody who's over the age of 16, but it's free range on kids under the age of 16. I think that would be declared unconstitutional. So you can kind of see that under existing law, which is there's not a recognition of fetal personhood. I think the federal government could probably pass a law that would, but it would have to be a clear statement, right? Because they're not going to find it implicit, and it would have to be on a Commerce Clause hook. But I think under existing doctrine, could I draft a statute that should be upheld? Yes, I could. Does that guarantee that either a statute like that would be drafted or that it would be upheld by this court? No, it does not.
Anyone else?
Yeah, I have the mirror image question about legislation, congressional legislation to outlaw abortion nationwide. And I think Senator Graham's bill, I'm not positive about this, but I think it cites as part of its warrant, 14th Amendment. Maybe because Justice Thomas has some qualms about Commerce Clause.
It cites both.
Yeah.
It invokes both, but it then doesn't actually tie the regulation directly.
Well, that was my question. In order for the court to uphold such a law, would it have to, as a prior matter, accept fetal personhood? And do you think there's do you think there's any appetite among the majority of the
Well, the court upheld the federal law outlining
partial birth?
Right. So, I mean, I think there was a concurrence from Scalia and Thomas in there, said no one's really raised congressional power here, so we don't have to address it. But it's been done before, more narrowly.
I would think that there would be no trouble, this court would have no trouble upholding the law on Commerce Clause grounds if it was properly drafted to invoke the Commerce Clause. No one in or affecting interstate commerce can use any item or material that has traveled in interstate commerce for the purpose of performing an abortion. I don't see how current doctrine would say that law is unconstitutional. Does anybody?
Justice Thomas wouldn't vote for it, but
Well, it's also most of the time economic activity.
Yeah, it's business activity, right? I mean,
The question was, would it be challenged? You bet on it.
activity.
no, when you say no, no person can buy or can sell or provide this service using items that have traveled in interstate commerce. How would you think he'd have problems with that?
I think yes, but there are many more interesting questions out there.
Okay.
I'd like to ask about the predictability of any Supreme Court decision, but it's triggered by what Adam said about the oral argument persuaded him. Back before history was recorded, we didn't do that. We never said we knew the outcome from questions. But if we did, I once did, we suffered. And I never made a nickel for predicting anything. But it seems that now there's more certainty among the reporters of the decision, the journalists, that they can predict the outcome by the time of the oral argument. Is that?
Or by the time of the cert grant.
That's what I was going to say. Sometimes we feel like we know when they take the case.
What did you say?
By the time of the cert grant, you don't have to make the argument.
Well, actually, before the argument, the media sort of builds it up as if to, so it's going to be surprised when it happens. So look, argue with me. I don't. Anybody heckle me?
I mean, I think that there are cases in which it seems very clear of the outcome by the questions that were asked. There's not a whole lot anymore, I think, of sort of devil advocates kind of questions where you're not sure. I
Depends
think.
on what kind of case you're talking about.
Yeah, right. I mean,
Yeah, I mean, in the big high profile cases in which you would sort of.
It used to be that Kennedy was a little hard to read, but that's gone now. I mean, you have Justice Kavanaugh sort of saying, well, here's how I'm going to write my opinion.
Yeah, I mean, he does that a lot.
Well, this is also, if you're looking back 20 years, say, this is a much more active bench. I think there was a time when it would have been hard to predict from the oral arguments what the outcomes were, because 3 or 4 of the justices would have asked virtually no questions.
Sure.
And unless all of the other justices are asking the same questions and pretty strenuously, you wouldn't have been able to predict. But now the justices ask a lot more questions. And I think one of the really interesting questions going forward is, now that they're going back from oral argument by telephone and the like, are they going to stick with their, asking the questions seriatim, or are they going to go back to free-for-all questioning? It's going to be really interesting.
They seem to like
They
this.
like the hybrid format. They're gonna.
Yeah, I
And
mean,
it takes a lot longer.
yeah.
Reporters aren't that crazy
Well,
about
not as
it.
long as when
I'm not sure
Daniel
they all
Webster
like
argued
it.
for like 4 or 5 days in a college case. I mean,
Is that a question?
Yes, thank you. And this is from a Planned Parenthood lawyer who's asking a gun question. And regarding the
That's what we've encouraged with this panel.
the gun sensitive places exception. For a bad guy with a gun to go into a mall and cause havoc, killing a dozen people, etc. But good guys with the gun were way more present and shot a whole bunch of people up because, maybe they, for whatever reason. You can imagine that a state would then pass sensitive area to include a mall. To what extent do you think, or do you think all the bad things happening in this country could it allow then someplace like Central Park or downtown Chicago having larger and larger sensitive areas?
I think that's what partly Erin was talking about with New York, that New York has defined Times Square as being quite extensive, if that's right.
Whether you thought it would.
Yeah, no, I think, really, frankly, it's a pretty underdeveloped, of all the areas that have gotten litigation, it's one that's gotten very little, because for the most part, the states either allow or don't allow, and so the focus was more on that. I think that what the court's gonna have to do is develop sort of at least somewhat objective criteria in thinking about it, like, government buildings, or, you could try and then, there was a lot of discussion and argument about like particularly crowded places. Okay, if you take that as a principle, how do you apply it? Does it matter if they're open air, if they're, a stadium that people are coming in with tickets for versus just Times Square and anybody's there? I really think like that, certainly the states that are going to pass these laws are going to make arguments that are a little more in that practical vein of, look, we should be able to sort of define sensitive as places that where a lot of damage could happen. I think historically that becomes a little bit harder, because if you're thinking about it through a historical lens, the sensitive places were a little bit more aimed at like either being somewhere that it posed a particular threat to like you couldn't bear arms before the king. So like that's sort of what the historical basis for government buildings was, or places where there's thought to be other security that's already there. So I really do think this is like, it's an underdeveloped area of litigation. It's an underdeveloped area of scholarship, frankly, too. So I think it's going to be one that, it's just going to take some time to sort of figure out the historical way to think about
In
it.
front of justice houses, this might be one. I think, is this it?
the end.
Okay, thank you to the panel. They were great.